everyone. Welcome back. So the last chapter we talked about court personnel and the people that worked in the court system. So today we're going to finish up and we're going to talk about court issues. So then we'll be finishing with the court section. So after this lecture, you'll be all ready to take your next exam, which is court organization, court personnel, and then court issues. Okay, so let's talk about the court issues. Share my PowerPoint with you. Okay, so this is just like what we did for policing. We did police organization, then we did police issues, and then we did police, police organization, police personnel, and then police issues, and then we just went through courts. We went through court organization, court personnel, and then now we're going to talk about the issues that courts have to face. Okay, so that's what we're going to talk about. Now, one of the big issues when you're talking about the court system is what we call unification. This is the organizational structure of the courts. Now, we talked about the federal courts is like the district courts, which is the trial court, and then the appellate division, and then the highest court, which is the Supreme Court. And we talked about New York, and New York has tons and tons and tons of different courts. And one of the big issues in New York is how can we simplify this organizational structure? Do we really need 15 different county level courts and then Supreme Court and appellate division of Supreme Court, and we still have town and village courts? So there's been a lot of push to try to simplify our state court system and make it more of a 3-level system that's similar to the federal system. The problem is our court system is set by our New York State Constitution. So a couple of years back, there was a resolution that was tried to be passed to open our New York State Constitution and make amendments to it. One of the things they really wanted to do is they wanted to open up the Constitution so they could rewrite how our court system was structured. The problem is that there was a lot of teachers that did not want that because there were other pension issues in the Constitution. They didn't care about the courts, but they cared about these pension issues. And they were afraid if the Constitution was open, it would affect them. So it was voted down. So we still basically have the same court structure that we've had before, and it's stayed the same, okay? So we have not actually consolidated our state court system because that didn't pass. I always think it was funny because as a lawyer, I was receiving all this stuff in the mail saying, vote to open the Constitution, the New York State Constitution, so we can fix all this. And then as a teacher in the union, I received all this stuff, don't open it, don't open it. So I was getting both arguments in the mail trying to convince me. But it did fail, and so we have not been able to consolidate our state courts in New York yet. So this is what I was saying, like this is all the different levels of courts in New York. It's so complicated. So the argument is there a way we could simplify our courts to just be these 3 levels that like exist at the federal level and instead not have all of these additional courts that exist? It just makes it so complicated, okay? So some states do have that. Some states, this is the federal system, this is the state system. And it's just much cleaner, easier, simpler structure. So that is what we're talking about by unified structure. And that's always a constant issue within the New York court system. Okay, so you have to think, what would be the benefits of this unification? Well, it would be a much more simpler system, right? We would have a much more simpler system. Students like you would have easier learning. You wouldn't have to learn so many different courts. You could have just one central court administrator instead of having each different level of court having their own administration. We just have one set court administration. So maybe it costs less to taxpayers. We have central rule makers, so you don't have all different rules for all different courts. So lawyers have to know, what does this judge say and what does this court say, and know all the different rules. If you had one uniform system, it would make it much easier. And like I said, it might save some money. So that's one of the court issues that we have to talk about or think about, is that unification. So here is another issue. You are on the jury for a murder case. What type of evidence do you think that the prosecutor will present to you throughout the trial? So think about TV and think about murder cases that you see on TV. When you see these trials, like, what do they usually involve? Well, they usually involve different levels of forensic evidence, right? We've kind of come to expect having forensic evidence in all cases. And a lot of this is because of the TV show CSI. In CSI, there's always forensic evidence, and they always take it to the lab, and they can always use it and figure it out pretty quickly. And this has created an expectation within the court system that all cases are going to kind of be like that. The problem is that's not really true. We don't always have evidence, forensic evidence in cases, right? And so one of the things we have to think about is what happens when we don't have forensic evidence? What if all the evidence we have is a witness testifying and just saying things that happened, but no DNA, no hair, no fiber, no fingerprints? What effect does that have on the case? So if you're a prosecutor and you have no forensic evidence, what's the jury going to think about your case, right? Or if there is a lot of forensic evidence and you're the defense, how does that affect your case? So this really can have an effect on both sides. The prosecutor could be in trouble when they don't have forensic evidence because maybe the jury doesn't believe it if there's no forensic evidence. They see it on TV and then there's none. So maybe it's a harder case for a prosecutor to show when there is no forensic evidence. And then on the other side, for defense, when there is a lot of evidence, there's sort of a built-in bias that forensic evidence is infallible, that it must be true. And that also isn't always true. And there can be mistakes and issues with forensic evidence. So the defense has to overcome the CSI effect also. So we always have to think in the court system how TV and media and things like that affect our trials, because they really can affect the ultimate outcome of justice in our system. Another big issue when you're talking about the court system are what we call problem-solving courts. So we've talked about this in multiple cases throughout criminal justice. So do you remember what problem-solving courts are? So at ours, they're mostly at the county level. So we call the problem-solving courts or specialized courts like drug court, veterans court, mental health court, domestic violence court. Again, at the state level, these are pretty much county courts. And these are courts that if one of these is the issue, instead of sending somebody through the formal criminal justice process, they go to these specialized courts, and there's special programs where the defense and the prosecutor and counselors and JACASA and all these groups who work, Veterans Affairs, they all work together with the defendant to try to aim for rehabilitation. So instead of just locking people up and throwing away the key and stuff like that, we've really developed these ideas of specialized courts. If we work together and if we kind of focus on the specific issues that defendants are facing, maybe we can move a little more away from mass incarceration and prison overpopulation and more towards the idea of rehabilitation and reintegrating people back into society in a healthy way. So one of the things you should understand with these problem-solving courts is that this is really a more proactive problem-solving solution. We're not just throwing somebody in jail, with convicting them, saying they commit a crime, and then throwing them in jail. We're problem solving. We're working with the defendants. We're figuring out what's happening. We're being proactive. We're coming up with solutions. We're integrating social services into this process. We have probation, and we have JACASA and drug and alcohol treatment programs, and we have services out there that are going to help these people that commit crimes to figure out the root cause of the problem and hopefully stop committing criminal activity, crimes, and move towards becoming more productive members of society. The other thing with problem-solving courts is they are team-based. It is not the defense against the prosecutor going at it in that sort of adversarial system. It's really all of the people working together, the defense, the prosecution, the social science services, the judge, the probation, working together to come up with a unified way so that we can try to, again, rehabilitate the defendant. A part of this sometimes also includes like a mediation between the victim and the defendant. So we don't want the victim to feel that there's no justice. So sometimes you have some sort of mediation where the defendant can meet with the victim, they can talk, and the victim can ask the defendant questions. Hopefully the defense demonstrates remorse, and you can kind of move towards more of a closure. Now, all of this goes under the judge. The judge is the one that supervises this whole process. So there's frequent check-ins, and they go back to court maybe once a month, and there's status checks to figure out where everybody is at any given time. And hopefully this progresses where you complete the program in one of these specialized courts and you graduate, and then you don't have a criminal record. You can move on and become a more productive member of society. Another huge issue with courts, and this has been way exacerbated with COVID, is the idea of speedy trial. So hopefully you remember that we have the right to a speedy trial in the Sixth Amendment in our Constitution. And there's often the idea that justice delayed is justice denied, right? If you don't get a speedy trial, a lot of bad things can happen. You sit in jail possibly before your trial, so you're getting punished basically for stuff before you even actually are convicted in a trial. Over time, people's memories fade, evidence gets lost, police retire. So there can be a lot of issues if you don't move the case forward with a speedy trial. Now, what can cause this? Well, lots of things can cause it. The prosecutor maybe can't get their hands on the evidence properly. With COVID, there's just a huge backlog because of COVID. They couldn't have a lot of trials at certain times. So then they had a backup of a lot of trials. And then on top of that, they just had a backlog anyway. So now you have all these trials waiting to work through the system. Why do we care? It's kind of like what I just said. You just have defendants that don't ever get closure. Like, what if it ultimately ends up they're found not guilty and they had to wait 3 years for that to happen? Think about the impact on that defendant's life for 3 years having this over their head when they ultimately could be determined to be not guilty. So it's really, really a fundamental part of our system. They've really tried to fix this. And they passed the Speedy Trial Act of 1974, which created really rigid deadlines when things had to occur. And one of the examples is you needed to, from the arrest until the formal indictment, you only had 30 days. You had to get that formal indictment within 30 days after arrest. Then you only have 70 days from indictment to trial. Now, what happens sometimes is the defense asks for more time. Because if you think about it, the prosecutor and the police may not move forward on the charges until they have all of their evidence together. So they may be ready to go. But then all of a sudden you're dumping all of this stuff on the defense. And the defense may not have enough time to go through all of this and prepare for the actual trial. So sometimes the defense asks for more time. And then that doesn't count against speedy trial. That's okay, because it's the defendant's right to a speedy trial. And if they ask for more time, then it doesn't violate the right to speedy trial. But we still do have this backlog of cases. Now, what are some possible solutions to this, especially now digging ourselves out with the cases from COVID? We could alter the way that we're assigning and scheduling cases. Remember, we talked about individual cases versus master calendar system. So sometimes we have judges that just do arraignment, and the other judge does trial. or you could have one judge do the whole case all the way through. One way may be to figure out how that will best, which method is best to move the case faster through the system. Another process that they're really pushing is, sorry, just trying to reduce the amount of trials. So they're trying all kinds of different things. We're trying to force more plea bargains. If you can get more people to plea bargain, then you have less cases that are actually going to trial. Sometimes if people won't agree, you can get punitive damages on people, like corporate cases. They're limiting that because then that makes people want to go to trial to get those damages. You could have things like the loser has to pay the attorney's fees. That might encourage more people to settle. ADR is an alternate dispute resolution. And so this can come in multiple forms: mediations, arbitrations, where the sides get together and try to negotiate something. You think about this much more in civil, but it does happen in criminal. Now, mostly lower level criminal cases, but sometimes, like we said, or what I was just talking about in my juvenile class, is sometimes when you get parties together for more minor offenses, the victim and the defendant can really talk and work things out. And then the victim feels fulfilled and satisfied with the result without actually having to formally go all the way through trial. And then you may be able to get the defendant to plead to something less or agree to treatment or something like that. So those are just ways to try to reduce the case load and have less cases. So this is your homework for this week, your Chapter 9 assignment. You're the administrator, you have all these cases. So this is just asking you, how could we move this through? How can we work this out? How can we get these cases through and try to lighten the court's load? So I just want you to kind of critically think through that. There might not be one solution. I'm just wanting you to critically think about what you think may be the best solution for that issue. Another big issue when you're talking about the courts is sentencing. So we have the trial, but then if the person's convicted, we also have sentencing. And sentencing can be very complicated for judges. There's a lot of different issues that judges have to follow. And it can be complicated. There's special sheets and references and how people are going to be sentenced that judges have to follow. And in the past, a lot of these guidelines led to super harsh punishments. And so we had a lot of people in prison spending a lot of time for not always the worst offenses. Drug offenses were receiving life sentence for some drug possession crimes. And so there's been a huge push to try to reform these sentences. Maybe we don't need to lock everybody up all the time. Maybe there's more productive ways, other goals of punishment that can achieve a result that would be more beneficial. We jail more people than anybody in the world other than like China and some countries in the Middle East. So what else could we do besides just locking people in prison? So there are the federal sentencing guidelines. Those are the rules that kind of set forth what judges should sentence for certain offenses. There's been a proposal to reform those and change the recommendations. Some crimes have what we call enhanced punishments. So you commit an assault, but if you have a certain weapon or gun, it enhances the punishment. Drugs, this came up a lot. So if you were caught with cocaine, it was one punishment, but if it was crack, it was enhanced and you got even more. So they've tried to reform some of those. They've tried to alter sentencing of juveniles. Maybe sentencing a juvenile to their life in prison for the rest of their life, maybe not the best thing. And they were waiving a lot of juvenile cases to adult courts and treating juveniles like adults. Maybe we can reform some of that and then reduce excessive sentencing for drug offenses, which I already talked about. Now, another issue with the courts is wrongful conviction. So I posted a video from the Innocence Project. It gives you an overview of what we're talking about with wrongful convictions. This is a relatively new issue that the courts are facing. In the past, there was always the belief that nobody's wrongfully convicted. If they're convicted, it meant they did it. And more research is going into this, and they're finding more and more that there are people that are wrongfully convicted. So courts have to face that. They have to understand that. So what are some of the facts that we know? We know 20 million people are behind bars. And if the wrongful conviction rate is only 1%, that means there's 20,000 people that are wrongfully convicted in our prison. And it's likely that 1 out of every 25 people on death row are wrongfully convicted. And what is that? We're going to put somebody to death and that maybe aren't really the ones that committed the crime. So courts are really starting to have to juggle this issue. In the past, it was almost impossible, still very hard to overturn convictions when somebody's convicted by a jury. But courts are starting to realize that mistakes can be made and are more willing to allow the court to review it again. There used to be a big push that we need closure, and you can't just have cases go on and on and on and on. But we're starting to have a recognition that we do need to worry about wrongful convictions. And they're starting to find with research what are some of the causes. Eyewitness identifications, faulty memories are bad, and so eyewitness identifications are inherently faulty. Junk science, we believed in forensic CSI for so long, and we've learned that some of it is just not good science, and we've convicted people with bad science. We know that enhanced interrogation techniques can lead to false confessions, and we know people do falsely confess, even though we used to think they didn't, they do, based on pressure and the methods used by police to interrogate. We know that there can be governmental misconduct. So police can do corrupt things, prosecutors can do corrupt things, and it can lead to wrongful conviction. In courts, a lot of times we allow snitches, like jailhouse snitches, to testify to reduce their sentence, and this has led to wrongful conviction. People are willing to say anything in court, even if it's not true, just to reduce their own sentences. And we know there's bad lawyers, there's unethical prosecutors, but even worse, there's some very bad defense attorneys that take people's money and don't really work on the case. So all of these are potential causes of wrongful conviction. We have to recognize them in the court system and understand that they exist. So this quote is crazy to me. So I just like to share it. So this is Antonin Scalia. He was a Supreme Court justice. And he said, "This court has never held that the Constitution forbids the execution of a convicted defendant who has had a full and fair trial, but is later able to convince a habeas corpus court that he is actually innocent." So basically he's saying that the Constitution, if the jury finds you guilty after trial, fair trial, and a full trial, even if there's evidence later that may tend to show that you really didn't do it, actually you are innocent, the Constitution doesn't forbid us from executing you as long as you had that fair trial. So I just want you to think about what that means in the sake of justice, and what do we want that? Is it better to just have closure in a case, or is it important that we have the truth? So that is one of the things you want to think about. Now, a couple other issues I'm going to go through fairly quickly. The exclusionary rule, remember, if evidence is obtained illegally, it can't be used as evidence against the defendant. So judges constantly are making decisions. Is the evidence going to be excluded? Understanding if you exclude that evidence, the defendant could go free and commit crimes. So it's a hard decision for judges, and judges have to make those decisions. Cameras in the courtroom. We're increasingly seeing more and more courts that have cameras. There are pros and cons to cameras in the courtroom. Do we like that? Do we want that? Do we want to turn our trials into like TV shows? And that can be problematic. People may act different if there's a camera in the courtroom than if there's not. So we really need to weigh that. But then having a camera in the courtroom increases transparency and allows people to see how our system works. Discrediting the courts. You see in more and more in recent years, people are starting to criticize the courts and saying that they only are deciding issues based on politics. always the courts were kind of held higher above all of the other branches. They were neutral, they were fair, they were just. And in recent years, there's been a lot of criticism that the courts aren't fair and aren't just. They're just political bodies, and they're just controlled by the political party that the judges belong to. And if you really believe that, it's really sad, because then we don't have any ways to assure that our system is fair. It's just political. Another big issue that courts have to worry about is violence. It's everywhere. Guns are everywhere. People have school shootings, shootings in malls, shootings in the public. So we know that violence, and then after COVID and during COVID, we've seen an increase of violent crimes. So we have to be aware that there could be violence in a courtroom. Think about the motion and the things that happen in a courtroom. If a person's convicted, they could spend the rest of their life in jail. And what would you do to try to avoid that? So courts have to be very, very careful and aware of violent threats that exist within their courtroom. Now, some are targeted. Sometimes judges, prosecutors are specifically targeted, and some are not targeted. Other violence just occurs in the courtroom, and it's not anybody particularly targeted. So courts have to be very aware of this potential violence, and they have to do what's called threat assessments. So police do this, Homeland Security does this. This also occurs in the courthouse. They have to identify the threat. So they have to see, is there really a threat? They have to assess that threat. Is it a true threat, or is it just somebody just, saying stuff? They have to investigate it. If they think that it is a true threat, they need to investigate it, and they need to decide what are some possible solutions to that threat. And then they have to manage that threat. So that is your homework. You need to do a threat assessment. So I posted a bunch of documents explaining it. You need to read the scenario, and you need to do a threat assessment and decide what you think of the threat. Okay? So that's it. That's all I have for today. And that's the only lecture for this week. So this week's a great week just to do the homework assignments and then really work on your project and really try to finish your data analysis. If you have a little bit to do, you have a little time this week to catch up on that. And then your, oh my gosh, the phase 7, the short summary of what your paper's about. Why am I drawing a complete blank? I posted a video explaining it, okay? So you want to just do those small pieces. They're short, they're quick, they won't take you too long, and then you can work in finishing up your data analysis. Okay, I hope all is well. If you have any questions, just contact me and I'll be happy to meet with you and talk to you about anything you need. I'll talk to you soon.